Good evening. I'm Claudine Wong. The state of California says it was an abuse of power. The Trump administration argues it was a way to protect federal officials and buildings. This is a battle between Governor Newsom and President Trump over who should have had control over the California National Guard last June. KTVU's Jana Kayama joins us live from the federal court building in San Francisco with the arguments made in court and the analysis from experts. Jana?
Claudine, U.S. attorneys with the Department of Justice say that there are still about 300 troops that are deployed in Los Angeles. They say that is completely justified, but the state is asking the federal judge for a permanent injunction, saying that it is against federal law. And this is a case that has national implications. Attorneys for the state of California emerged from the federal building in San Francisco Wednesday with boxes of files after arguments wrapped up in the three-day trial, Governor Newsom versus President Trump.
One of the problems is we really don't have much precedent for this kind of situation.
UC San Francisco law professor David Levine says in court the state argued Trump's deployment of National Guard troops to Los Angeles in June violated an 1878 federal law, the Posse Comitatus Act, which bans federal troops from conducting law enforcement on domestic soil. Deputy Attorney General Megan Strong said, quote, Exhibit 39 is a document that shows defendants coached law enforcement to substitute the word protection for security because they knew the word security would violate the Posse Comitatus Act. It simply shows they knew it was unlawful. For the defense, U.S. attorneys argued that President Trump has the right to intervene to protect federal assets, saying, quote, the question is whether the conduct was itself blatantly lawless. And what the record shows is that the Department of Defense was sensitive to the Posse Comitatus Act, provided training and direction to stay within the confines of that and other laws.
I could easily see Judge Breyer saying it is okay if the troops are protecting those properties and maybe a very tight perimeter around them, but that what might be problematic is when those same troops go out with law enforcement.
In court, Judge Charles Breyer asked why, nearly 2 months after the violence in June, some 300 troops still remain in L.A. and what the limits are to military deployment, saying, quote, Congress acted as it did in 1878. They pulled out the military not because the laws were being perfectly executed in the South. They pulled the military out because they didn't want them to execute the laws.
We want to rule relatively quickly, as he did with the preliminary injunction case, but I think he'll want to take the time to write a careful opinion because he knows it's going up to the Ninth Circuit and probably the U.S. Supreme Court.
And just this past hour, California Attorney General Rob Bonta issued a statement saying he remains confident in their ability to win this case. He said the attorneys presented facts and he looks forward to hearing the judge's decision soon. I also reached out to the Department of Justice attorneys. They declined to comment. Claudine?
All right, Jana, we will wait for that ruling. Thank you.